So let's break it down here. So the first thing that I'm going to do here is I'm going to give you an actual overview of what the SEC has alleged towards Coinbase. And for those of you in the Pulse Chain community, this is very significant. We need to stay abreast of all these updates and these press releases that are coming out and these court hearings, so we can get a really clear picture about how this is evolving real time. So the SEC charges Coinbase for operating as an unregistered securities exchange, broker, and clearing agency. Coinbase also charged for the unregistered offer and sale of securities in connection with its staking as a service program. So this is on sec.gov/news/press release 2023. This was on June 6th of 2023. The SEC commissioned today charged Coinbase Inc. with operating its crypto asset trading platform as an unregistered national securities exchange, broker, and clearing agency. The SEC also charged Coinbase for failing to register the offer and sale of its crypto asset staking as a service program. Unregistered exchange, broker, and clearing agency. So what do they mean by that? According to the SEC's complaint, since at least 2019, Coinbase has made billions, with a B, billions of dollars unlawfully facilitating the buying and selling of crypto asset securities. The SEC alleges that Coinbase intertwines the traditional services of an exchange, broker, and clearing agency without having registered any of these functions with the commission as required by law. Through these unregistered services, Coinbase allegedly, and why do they say allegedly? Because it hasn't been proven in court, they provide a marketplace and bring together the orders for securities of multiple buyers and sellers using established non-discretionary methods. Okay. So SEC saying that, all right, we're going to wave a magic wand. We're going to say that these things out there are securities. And because we waved our magic wand and we deemed these things securities, now we're going to charge you as the person who is disseminating and profiting off of the sale of these securities. Next, engages in the business of effecting securities transactions for the accounts of Coinbase customers and provides facilities for comparison of data respecting the terms of settlement of crypto asset securities transactions. So there's huge assumption here. And the big assumption is, again, they have a magic wand. They're going to wave it, and they're going to say that all these things are securities, which gives them the precedent to be able to move forward and attack Coinbase. So the SEC alleges that since 2019, Coinbase has been engaging in unregistered securities offerings. Okay, we know that. And also, they're attacking the staking as a service program, which allows customers to earn profits from proof of stake mechanisms of certain blockchains and Coinbase's efforts. Through this staking program, Coinbase allegedly pools each type of customer's stakeable crypto assets, stakes the pool to perform blockchain transaction validation services, and provides a portion of the rewards generated from this work to its customers whose assets were part of the pool. Coinbase failed to register its offers and sales of this staking program as required by law. So what are they talking about here? In order to be a validator, you guys have seen it. If you use Coinbase, use other things, they solicit you to lock up your Ethereum. You're going to get a small APY, and then they're going to take the rest. And that's because they are using your Ethereum to create validators. That's what's happening here. Nate, I'm going to invite you as a co-host here, just to be there and to pump this algorithm. And this is a direct quote from them. And guys, we're almost done with this, and we're going to kind of get into the summary of what happened today. I just wanted to give you a very thorough understanding of what we're dealing with here. We allege that Coinbase, despite being subject to securities laws, commingled and unlawfully offered exchange, broker-dealer, and clearinghouse functions, said SEC Chair Gary Gensler. In other parts of our securities markets, these functions are separate. Coinbase's alleged failures deprive investors of critical protections, including rule books that prevent fraud and manipulation. I wonder if fraud and manipulation, folks, is already against the law. I'm just going out on a limb there. I don't know. Proper disclosure, safeguards against conflicts of interest, and routine inspection by the SEC. Further, we allege Coinbase never registered its staking as a service program as required by the securities laws. Again, depriving you poor investors of critical disclosure and other protections. You simply can't ignore the rules because you don't like them or because you'd prefer different ones. The consequences for the investing public are far too great, says Gurbir S. Graywall, director of the SEC's Division of Enforcement. As alleged in our complaint, Coinbase was fully aware of the applicability of the federal securities laws to its business activities, but deliberately refused to follow them. While Coinbase's calculated decisions may have allowed it to earn billions, it's done so at the expense of investors by depriving them of the protections to which they are entitled. So, SEC, guys, opinion time. Okay, I'm going to kind of go out on a limb here. SEC, where are the victims? Where are the victims of all these things? You know, where's the societal cry for help to the SEC to come in and swoop and fix everything? Because that's what the government does so well. Now, I want to point something out too. We're going to move on. But guess what? I'm just going to read the top headlines for today, really this month. So first headline, JP Morgan to pay $18 million for violating whistleblower protection rule. January 12th, SEC charges Morgan Stanley and former executive Pawan Passy with fraud in block trading business. Fraud. SEC, Morgan Stanley and the executive. How come that's not on headlines? Can somebody tell me that right now? I don't get that. Strange. Some pretty big names here, guys. CEOs of medical device startup companies, Barnbridge, that's a problem. Florida real estate developers, some big names in here, folks. But crypto is the one that gets all the scrutiny. But we don't hear anything about JP Morgan's executives having to pay 18 mil. But you better know that Richard Hart, you're going to hear all about him and having to pay 12 mil for some reason. All right, let's keep going here. I lost most of you there, and that's probably ultimately a good thing because, as you can see, I barely graduated. What? High school. Okay. Let's get into this. All right. Bunch of you guys are street lawyers. Just to let you know, I'm a street lawyer, right? I'm a good old legal eagle. I don't know anything. You shouldn't listen to me. This is your last chance to turn away. Today, what we're going to do is take an in-depth look at the SEC versus Coinbase case that happened today. And, it's a legal showdown that has a significant amount of impact on everything that we're doing here on Crypto Twitter. And quite frankly, I don't care if you're a Bitcoiner. I don't care if you're from Ethereum. I don't care if you're in Pulse Chain or not. I don't care if you're with Ripple. We're all feeling these effects. So we all need to arm ourselves with the armor of knowledge, because that's what's going to help us move forward and speak intelligently about these things. So I would say it's a potential game changer for the cryptocurrency world, depending on what happens with this case. Yes, it's that important. So we're going to try to, unravel some of the complexities that are happening here. So the SEC versus Coinbase case was discussed today, January 17th, and you might be hearing a replay. It revolves around whether these 12 tokens listed by Coinbase are securities. And I gave you the initial context of the actual charge that happened back in June. What's interesting is the judge who's presiding has a pretty big hesitation to immediately rule. And that could reflect it does reflect the intricacies of what we're dealing with here. and the considerable impact and outcome. I will say that based on what I've heard, this judge did her homework. I am super happy about that, because you guys, people think that judges are superhuman. They're not. They're you and me. They just decided to put themselves through hell for about 8 years, or actually longer, much longer. So they're regular humans, and sometimes regular humans don't feel like putting in the work to really understand the intricacies of these new technologies. And that's also why you see technology in the law, you see there's a gap there. Okay. Technology takes off and law lags behind until people like this judge decide to take responsibility to understand these things. So at the heart of this case lies the Howey test. The Howey test, obviously, we talk about this all the time here. Most people in here know about it. It's a legal standard used to determine if something is a security. The SEC argues that these tokens meet this standard because they're purchased with an expectation of profit, which is a core element of the test. There's 4 legs, and everybody think that's the end-all be-all. There's actually many other things that they can use to determine whether or not this is a security, but those are the primary 4. That's what all the crypto bros and street lawyers talk about. All right. So the SEC argues that these tokens meet this standard because they're purchased with an expectation of profit, a core element of the test. But the simplicity of this argument, it belies the complexities of modern digital assets. What do we mean by that? Guys, these aren't orange fields. These aren't orange groves from the 30s and 40s or 50s. Okay, that's not what this is. All right, this is something completely different. And we're trying to use old laws to apply to new thinking and new sorts of assets. Okay, anything can be a security depending on how you use it. I want to point that out too. But digital assets and tokens are something that's very different. There's many different angles to hit this from. I think that, for example, the Richard Hart case, which some of you might be listening in that are outside of the Pulse Chain community, I would highly encourage you to take a look at what's happening with that case and the all-star team that Richard Hart has compiled. And he's attacking it from the standpoint really of rights and of speech, whereas Coinbase is more attacking this along the lines of the detailed, explicit and implicit interpretation of the Howey test. So, Coinbase's defense brings us to a crucial point today, which is these tokens do not come with an explicit investment contract. This is not just a minor technicality. It's a fundamental challenge to traditional securities laws. In the world of stocks, bonds, securities typically come with a clear contract that outlines investors' rights. It outlines their obligations. It outlines the expectations of profit or not. So those are the disclosures, the disclaimers. But with these tokens, no such formal contract actually exists. This absence raises a significant question. Can a token be classified as a security if it doesn't explicitly promise investors a share in profits or decision-making power, as traditional securities do? So critical thinking here, ladies and gentlemen, for those of you in the chat, why do you think this whole time, many times before, I said, why do you think you open yourself up to additional scrutiny when some of you decide to create a DAO for your project? Why is that? It's because it's centralized, it's governance, all right? And a lot of times people have to set that up. So that it creates an additional attack vector towards your thing. Let's keep going. The judge's probing questions to the SEC underscored this dilemma. So this judge, I'm telling you, man, you guys have to listen to, and I might upload this as well. You need to listen to the whole thing. It's quite long. Put it on, super speed here. But this judge came prepared, and she had experience with this prior. She asked very, very good questions, and she challenged the SEC in a very, very strong way. She did not let them off the hook. And it felt really, really good. It felt really, really good. Now, In the world of feeling really, really good in crypto, the next day you can feel really, really bad. So we don't get our hopes up, right? Let me see some reactions in the chat if you agree with that statement. Good God. So let's keep going here. If these tokens, let's go back. Sorry. Yeah. The judge's probing questions to the SEC underscored this dilemma. Particularly telling was the question about the right of rescission. Huge moment. A standard right in security investments. What is the right of rescission? So essentially, the judge asked the SEC lawyers whether or not these investors would have the right of rescission, which is a standard right in security investment. So the question is, what is the right of rescission? The right of rescission refers to the legal right of an investor to return a security and receive a refund of their investment. Now, the right of rescission it's a little bit different in terms, from my research. Remember, I barely graduated high school. It's a little bit different with securities rather than the right of rescission and other things. So you'd be able to receive a refund of your investment plus interest, if I remember correctly, if the security was mischaracterized or if it was sold in violation of securities laws. This right is typically applicable in situations where securities are sold without proper registration or without adequate information, which are both requirements under securities laws. So what did the SEC lawyers say? They said, yeah, investors would have the right of rescission. If these tokens were indeed unregistered securities, would investors be entitled to this right? They said, yes, this question is crucial, in my opinion, because it touches on exactly what we've been talking about, what these tokens represent and the legal rights that come or don't come with them. So in terms of, if we look at the scrutiny of the Howey test and the right of rescission, it's relevant in examining how the Howey test applies to cryptocurrencies. The absence of a formal investment contract with cryptocurrencies raises questions about whether or not the right of rescission would be applicable. So if there is no investment contract, then the investors would not have the right of rescission whatsoever. So it just felt like the judge was really, really testing the grounds upon which the SEC was bringing all of these arguments. And it felt good, really felt good to hear her do that. When you hear somebody questioning somebody else, or you hear an argument, you're always like, hey, I wish he would have said that, or I wish she would have said that. Well, this judge was saying all those things, and she wasn't happy, and she wasn't nice about it. The next thing that's interesting, she starts probing and pushing and bringing up intellectually testing, let's say that, the SEC stance on Bitcoin. So the comparison of Bitcoin to the tokens in question in the SEC versus Coinbase case was particularly notable for a couple reasons. And the reason here is you've heard many times in congressional hearings, you've heard reporters, you've heard a lot of folks press Gary Gensler and his squad of federal bureaucratic goons on whether or not, can you define Bitcoin for me? And if you've noticed, in every single situation, they've squirmed their way out of the question. They don't want to talk about that. So obviously Bitcoin has been regarded as the original cryptocurrency, and it's generally viewed by many as a decentralized digital currency. I would certainly say I'm agreeing less and less with that as time goes on. Not only from a technology standpoint, but also from the actual asset and where that asset is centralized in wallets. So, but regardless of that, there is no central issuing authority or administrative body. That's what I want you guys to keep in mind right now, moving forward. So other tokens, like those listed by Coinbase and under scrutiny in this case, they might have different structures, including being part of projects with more centralized governance or specific use cases within those platforms, right? This raises the question, what actually differentiates Bitcoin from other tokens in the eyes of the law? And After we get that question, why, or that answer, why is this distinction important for actually classifying them as securities or not? And this is a tactic I think that Coinbase is using to force the SEC's hand to actually define what Bitcoin is, because they can use that. They can use those words against the SEC because the logic just doesn't add up. There's a lot of things that don't add up here. The SEC has previously indicated that it does not view Bitcoin as a security. What's interesting, it does not now view Ethereum as a security. Now, I could put my opinion in there and go freaking tinfoil hat, go crazy with that. But Gary Gensler now says that Ethereum is, quote unquote, sufficiently decentralized at this point. So where's that line? Okay. At what point in time do you become sufficiently decentralized? Okay. What metric do you use to measure that? And if you can quantify that and you can measure that, why don't you share that with the rest of the world? Please, Gary, I would love that. So let's keep going here. So the SEC previously indicated that it does not view Bitcoin as a security. This is primarily because Bitcoin does not represent an investment in a common enterprise, how we test stuff here, and its value does not depend on the managerial efforts of others, both key components, okay, of the Howey test. By contrasting the tokens in question with Bitcoin, Coinbase aimed to highlight, in my opinion, the potential inconsistencies or lack of clarity in the SEC's approach to declassifying cryptocurrency. And they squirmed out of it, folks. Here's what I find interesting, right? I mean, laws should be written so that the common man can understand them. How many hundreds of thousands or millions of pages of law do we have? And when it comes to securities, we can't even write the law in such a way that is very simply understood by everybody. Why are we going through all of this litigation? Why are we going through the courts to get all of this clarity if it's so simple? Okay, and these are high-profile companies, high-profile lawyers. Not only that, you're spending millions upon millions upon millions of dollars of taxpayer money to tie this up in court. It's extremely frustrating. This is the bureaucratic arm of the federal government, of any government. It gets worse and worse and worse. And they think that their funds are unlimited. What did they get? They asked Congress for $5 billion and complained when they only got, what, $3 billion or $4 billion? Complained. 5,000 people on staff there. Got a brand new building, by the way, guys, a while back. It's real nice. $200 million, $250 million building. It's beautiful, guys. You guys should see it. It's incredible. Take a selfie in front of it and tag me, please, if you're in the DC area. So the SEC had previously indicated that it does not view Bitcoin as a security. This is primarily because Bitcoin does not represent an investment in a common enterprise, and its value does not depend on the managerial efforts of others. Okay, we understand that those are those key components. But they're trying, I think Coinbase lawyers are trying to get them to talk about it so they can use that against them. Because if they can talk about it and use it against them, it's very easily approachable here. What differentiates Bitcoin from anything else, right? What's going to differentiate Bitcoin between Pulse Chain? Very interesting question there too. The Howey test, established in 1946, can't apply to digital assets. Uh-oh. Street lawyer coming out with his opinion here. Things are too different. Things are too diverse. This is an evolving world of digital assets. And make no mistake, ladies and gentlemen, the reason why this is not moving forward is the following. If you've been on this earth for long enough, you're going to understand that problems, in the government's eyes, problems don't need solving. Because problems garner you one of two things, or both. They garner you more money, or they garner you or your buddies more power. And I promise that's what we're dealing with here. I promise you that's what we're dealing with. Very interesting quote here from the judge. I want to point this out. She says the DeFi people, and this is talking towards the SEC lawyers, the DeFi people, for example, have what I think is a really fine, amicus brief explaining to me what the wallet really is and what staking really is. And that actually, in some respects, makes more sense to me than the commission's description of the complaint. How many folks in here right now? How many folks in here saw the court documents from Richard Hart and Pulse Chain and laughed because they got so many things wrong? How many? They thought that they could just create these things. Here's probably what it is. Okay. So it's spray and pray. They're hoping that something sticks. They're going to tie people up in litigation and they're going to drown them in legal fees. Which is a little bit of a different ballgame when it comes to big companies like Coinbase or individuals who have significant resources to be able to fight all of this. So 2 things I want to point out here. And this is very significant. Actually, I don't know if I should move forward here or not. Let me kind of scan down and see my notes. Guys, amicus brief. If you think that the amicus brief does not matter, I think this solidifies the fact that it absolutely does, because the amicus brief that was written on behalf of Coinbase is now being used by the judge to seek clarity from regular DeFi people as to what is and what is not decentralized finance, and what is not staking, and what is not a wallet. That's so important, folks. Thank God for this judge. That's how I feel. She's actually listening. She's taking the time to go in and figure out what all of this stuff is. And once you just do a little bit of research, if any one of these judges did a little bit of research, right under the surface, all the answers that you seek are right there. Okay? To quote Aladdin, it's a whole new world. Don't you dare close your eyes, princess. Okay? Hexblaw, that was for you, by the way. Recognition of DeFi expertise. Here is why that statement was so notably significant. The judge's acknowledgement of DeFi, decentralized finance, the community's actual expertise is extremely crucial because it implies that those actively engaged in the crypto space might have a better or more practical understanding of how digital assets and related technologies function than regulatory bodies. Oh, no shit. You don't say. Absolutely. That's what that is. This is important. This recognition challenges the traditional dynamics of legal expertise, where regulators are usually assumed to have the most authoritative knowledge. Again, folks, I'm going to point this out. The law and technology, there is a gap in between. There is a margin that the law is trying to always close. Technology is always ahead every single time. So in this case, in this instance, these guys are being drug out into the deep end and drowned by regular people like you and I. Do not doubt me on this. There are people, most of the people in this room right now know more about decentralized finance than 99.999% of the entire world's population. The people that I'm looking at right here, the folks that are going to be hearing this on YouTube, the folks that are going to be sharing this and listening on Twitter in the next couple days, these guys are being drug out to the deep end and drowned because they don't know and they don't seek to know. They seek what? We talked about it. They seek power and they seek money. All right. And they seek power to make other people more powerful as well. In this instance, in this case, I think it's a handful of the biggest banks in the world that have been doing business mafioso style with Western governments and governments all around the world for many, many, many decades. And it's the same old story, guys. Rinse and repeat. The judge's statement and this clarity is vital, super vital, that she would look at the amicus brief to understand what this stuff is, because she doesn't understand it from the SEC. It's super vital in a complex case like this, involving extremely nuanced tech. I would say that it highlights the importance of all of the effective communication and accurate representation of technical concepts. And sometimes it's very difficult in a legal way to explain those. So she's willing to kind of go outside, like think outside the box a little bit, push the paradigm a bit, and take a look to see what regular folks in DeFi have to say about it. And she got understanding, which is cool. The judge finding the DeFi community's descriptions more compelling than the SEC's could influence moving forward how the court interprets key concepts related to crypto. This could lead to a more informed and technically accurate legal understanding of digital assets. It may also, ladies and gentlemen, suggest a willingness of the court to consider perspectives outside the traditional regulatory narratives. And they have to do it because all of the knowledge and all of the understanding about what this technology is it was born out of the private sector. Okay. Now, some people would say, oh, CIA started Bitcoin and blah, blah, blah. Okay, fine. Maybe the flywheel was started by the government. But guess what happens? Every single time you give the private sector an opportunity to make something better through incentivization, through meritocracy, through capitalism, it takes off. Okay? Government gets involved, it gets a little quirky, gets a little weird each time. So, the judge finding the DeFi community's descriptions more compelling than the SEC could influence how the court interprets key concepts. This could lead to a more informed and technically accurate legal understanding of digital assets, which is what we want. It may also suggest a willingness of the court to consider perspectives outside of traditional regulatory narratives, which could lead to more nuanced and technology-informed legal decisions. Additionally, legitimacy of DeFi and community involvement. The judge's positive reception of the DeFi's community, their input, legitimizes the role and importance of community-driven insights in shaping legal and regulatory discussions about cryptocurrencies. It demonstrates that the crypto community can meaningfully contribute to legal discourses, potentially influencing regulatory approaches. Okay, so what have we said? You can rule one of two ways, which we've seen. You can rule by enforcement, or you can legislate by enforcement, or you can legislate and create new legislation through what? Okay, so we've got enforcement and we've got collaboration. And the SEC chose violence. And they've chose violence for a very long time. And they screwed up a lot of people's bags. They've screwed up a lot of legitimate businesses. The library folks. How many people are employed there? How many people had to go find new jobs? How many children got disturbed because their mom and dad lost their business opportunity, their job there? These are things that we have to talk about. Has the SEC done more damage than the cryptocurrency at large at this point? What do you guys think? We to compare cryptocurrency to anything else out there, you have $100 trillion asset class that cryptocurrency doesn't shake a stick at, which is absolutely wrought with fraud, deception, backdoor deals, the US dollar. Let me ask you something. Can you do a line of cocaine with a Bitcoin? No. Can you do a line of cocaine with a US dollar? Yes, you can. All right. That sounds crazy, but it's to illustrate a point here, folks. It's to illustrate that the US dollar is used for more criminal activity around the world than any cryptocurrency possibly could. This demonstrates that the crypto community can meaningfully contribute to legal discourses, potentially influencing regulatory approaches. This statement, ladies and gentlemen, to summarize everything up here, and this is just about everything that happened, minus tons of quotes, cool quotes. You guys got to listen to it. The statement could signal a potential shift in how courts and regulators approach these cases. Such an approach could lead to more balanced, informed, and effective regulation that supports innovation while ensuring adequate consumer and investor protection. So that is 34 minutes. I thought it was going to be actually much shorter. So if anybody has any questions, raise your hand, pop up. I'll take questions for about 5 minutes, and then Got to get off here and go study for my GED. So let me know what's up, guys.